Hello, everyone. My name is Lisa Honka, and I'm the owner of Your Key to Senior Living Options. Today, we are joined by Mary Trotter and Ed Soulsby, and they are going to speak about legal papers that you need here in Florida. So, I'm so grateful that everyone's joined us. This presentation will be archived on my website. So, if anybody is looking to share it with a family member or replay it, you'll be able to see it in a couple days once we do archive it. And again, Ed and Mary, I've been working with you for years and years, and I know how professional you are and how the families that I send your way are very grateful for your services. So again, I'm so grateful that you can spend some time with us this morning and join us and share with our viewers your knowledge on how to keep people safe legally here in Florida, which is much different than other states. So again, thank you for joining us, and I look forward to speaking with you on the flip side about, again, all that you've shared with us. So again, go ahead and take it away, and thanks for joining us.
Okay. My name is Mary Trotter. This is my partner, Ed Soulsby, and together we make up the law firm of Trotter and Soulsby. Ed and I are the only board-certified elder law attorney in the Villages. What board certification is a program by the Florida Bar so that people would know which attorneys specialize in which areas. And in order to call yourself a specialist in elder law, you must be board certified. Now, we're going to be talking about basically estate planning and the documents you need if you become incapacitated. The basis of all Florida estate planning is our homestead, and it is one of the most important things, and it's very, very different than other states. Homestead is provided under the Florida Constitution, and there are three types of homestead, but all have one purpose: to preserve the family home.
So the first type is what most Floridians are familiar with when it comes to homestead property, is the property tax exemption. That's where the Constitution gives you the ability to keep your taxes low so the county can't increase the value of it from year to year by more than 3%. So when you become a homeowner in Florida and you are a primary resident here now, you definitely want to go up to the property appraiser's office so that you can file your homestead exemption, lock in the value of the home so that going forward, they're not going to increase it as much as they want by as much as 10% if it's not Florida homestead, but capped at 3% each year to value your property for taxes. But it's important to do that between January 1 and March 1st of the year you're applying for. So if you purchased a home this year, for example, you're going to want to do it between now and March 1st. Otherwise, you're going to have to wait until 2025. The next type of homestead protection or provision is the protection from forced sale by creditors. So under Florida law, if you happen to have credit card debt, medical debt, even Medicaid benefits that were provided to you during your life, your home is 100% protected from the reach of those creditors as long as you're leaving your home to a loved one. If you're leaving it to a friend or to a charitable organization, that will open the door for those creditors at your passing to say, great, sell the home and we'll collect what we're owed, and then whatever may be left will go to your beneficiaries.
And when Ed says loved one, he means family member loved
yes.
one.
Yes, sorry. Yeah, so yeah, it could be a spouse, children, grandchildren, even cousins. As long as it's a family member, it will be protected from the reach of those parties. The third type of provision covers the situation in which you may own the home in your name alone, but you cannot disinherit your surviving spouse or any minor children you may have. So when it comes to a surviving spouse, unless the two of you have signed a prenup agreement or a postnuptial agreement waiving your rights, you cannot disinherit the spouse from the home. They will have an absolute right to live in a home at minimum for the rest of their life, and they'll be responsible for managing that home during their lifetime. The homestead in Florida is also exempt from Medicaid and from VA. So if you're applying for those type of benefits, they will not count the home as an asset against you for purposes of getting those benefits.
We are one of the only states where there is no Medicaid recovery on the home as long as you leave it to a family member.
Yep.
It's very difficult to lose your home to Medicaid in Florida.
And then with the homestead, I mentioned briefly earlier about the surviving spouse having a life estate interest, and that's the minimum that they have. They also have the right to claim 50% of the home if they wish to, as long as they've exercised that right within the time limit permitted by law, so that they can own 50% of the home. And if it's sold, they'll walk away with 50% of the proceeds, with the other 50% of the proceeds passing on to the first spouse to pass their family.
So wills. Many people do estate planning with a will, some with a trust. Wills are only control assets that are in your name alone. Many people do not understand this. If you own an asset jointly with another person with right of survivorship, the will does not control that asset, nor does it control any asset that is payable on death to another person. They do not avoid probate, and wills do not plan for disability. Living trusts plan for disability, and so do powers of attorney, but wills do not. Your personal representative, or executor, as many states call it, has no control unless you have died. They do not protect you from a guardianship proceeding. They are fully public after death. If your will is from another state, you do need to have it reviewed by a Florida attorney. Now, many people believe that if a will is from out of state, it's no good. That's not true. It could very well be good, but it may not do what you want it to do.
Exactly. So we need to look at a few things when we're reviewing your will. So one of those things we look at is if your personal representative, that's what we call an executor in Florida, is qualified to serve in Florida. In Florida, your executor or personal representative has to either be a family member, which could be your children, your in-laws, even a cousin, or someone married to your cousin, or it has to be a Florida resident. So if you've named in your will outside of Florida a friend who lives in that state, or even your attorney from that state, they're not qualified to serve unless they move to Florida and become a resident. Not even your attorney, if they're licensed in Florida, they cannot serve because they're not a resident of Florida. So it's important to make sure that your personal representative is qualified. And unfortunately, if your personal representative has a felony conviction, they're not qualified, period. So you have to go and look for another person. We also look at Florida homestead. Now, we've talked a little bit about that already in terms of making sure you've left it to a surviving spouse if it's in your name, unless there's a marital agreement in place waiving your rights. And we want to make sure that it is going to a family member, that it's not opening the door for creditors. We actually had a case not too long ago where we had a young lady come in. Her parents had passed away from injuries in an automobile accident, but unfortunately, they had injured other parties. They were the cause of the accident. So she brought in her parents' wills, which were from Michigan, because that's what she thought was the only wills that she had in her possession. And she brought those in, and we looked at them, and there was a direction of sale of the home. And so that opened the door for creditors, including those injured parties. And she was really, scared that she was going to lose her parents' home. So what we did, Mary and I decided to come up with some arguments, went back and forth, because the arguments are good until a judge tells us no. But what happened was the daughter ended up coming back in. She had discovered as she was going through her parents' effects, subsequent wills after they moved to Florida, and it no longer had a provision of sale. So she was able to go home and know that she'll be able to keep the home. Those injured parties will not recover against the home. So it's always important to make sure that you're leaving your home to family members and there's no direction of sale in the home.
But don't worry about the injured parties. It was very good insurance.
Yes.
So.
So then we also look to see if you've left your surviving spouse a minimum amount. Under Florida law, a surviving spouse is entitled to 30% of everything you own, whether it's real estate, investments, retirement accounts, life insurance policies. If you have left your surviving spouse less than 30% of your assets, they will have a right to exercise a spousal right called the elective share and pursue recovery against those assets. Now, it's not 30% of every asset, it's 30% of the total. And if, say, for example, your spouse left a life insurance policy to their children, you're entitled to recover that portion of that for your elective share. So it's important to make sure that your spouse is receiving what they're entitled to. Now, if you've entered into a premarital agreement or a postmarital agreement and waived your rights, then that elective share won't be available to the surviving spouse. Am I missing anything else there?
I think you did very well.
Okay.
The other thing is we often see wills and also trusts that simply don't work because the money is not there. People do not understand that payable on death takes the money out of the estate. So they may leave 40,000 to this person, 50,000 to this person, and then put payable on death on all their bank accounts. So the only thing that goes through the will is the house. And the house is part of the residuary, which means it would go to the residuary beneficiaries, which are the remainder. So those specific bequests cannot be done because there's simply money not there. And people often are surprised that their wills will not control all of their assets. So we always make sure there's money in the estate so that those bequests can be done. Now, the last thing we look at is, well, one of the things is the will self-proving? In Florida, it is required that one of the witnesses to the will go to the courthouse and sign an affidavit. They saw you sign your will and that you were competent when you signed it. Do you know how hard it is to find witnesses from 30 years ago that are in Idaho? It's hard. So Florida has something called a self-proving will, and many other states do as well. A self-proving will, we don't have to find the witnesses. Now, a will is valid if it is signed with two witnesses, but we still have to find the witnesses. Only if it's self-proving do we not have to. So how do we know if our will is self-proving? Well, you need to look at the will, and you'll see that you signed it, and then you'll see that your witnesses signed it. And you will have either 2 or 3, depending upon the state. Florida only requires 2, but 3 is okay. Now you have a valid will. It will be self-proving if you signed a second time saying you saw your witnesses sign your will in your presence and that they saw you sign the will. And then the witnesses sign a second time saying they saw you sign, that you saw them sign, that they saw you sign your will. And that is notarized. So wills do not have to be notarized in Florida. Self-proving wills do. And then the last thing we look at is there a no contest clause? And we just simply tell people that doesn't work in Florida. They are against public policy. But Ed has some solutions to that.
Yeah, usually a state will permit you, if a beneficiary brings an action to challenge the terms of the trust or will, for example, because they disagree with whatever they may be inheriting, that if a beneficiary brings that action, the state permits the will to say, or the trust to say, that you're disinherited, you get nothing because you brought an action. In Florida, as Mary mentioned, we can't do that. It's against public policy. However, we do put a provision that makes it more difficult for such beneficiaries to bring a challenge, because if they do, their share may be significantly reduced if they lose the action. And then they'll be responsible not only for their legal fees and costs, but for the legal fees and costs of the parties defending the document. So we can't control what they will or will not do, but we can make life more miserable for them if we can.
Now, wills go through probate. What is probate? Well, probate is simply the process through which your assets change title into the names of the beneficiaries you wish them to go to.
Mm-hmm. So in Florida, the probate process is quite intricate. It can last anywhere from 7 to 15 months, depending on what we're dealing with, the type of assets, any creditors, even beneficiaries. So it's not one of the easier states to complete a probate in. California is just as bad, but many other states have easy probates. It's as easy as filing a will in public records, and that transfers title on real estate. But not Florida. We have to go through a process, submitting your will to the court, getting someone appointed, notifying creditors and the heirs, reporting back to the court what you own, and then ultimately providing a full accounting to all the beneficiaries. So it can be quite a cumbersome process, and I've had some even last 2 years or more, depending on who we're dealing with.
The shortest one I've ever seen was 7 months, and Ed did it. I was astounded.
It was just a one-time thing. The planets aligned, and I was lucky. And so, but yeah, no, we want to avoid probate if we can, because wills only control those things in your name alone. As Mary mentioned a little bit ago, if you have a beneficiary on your assets or you own something jointly, the will does not control those assets. Those assets are going to pass to those persons that you've named or parties you've named. But there are ways to avoid probate. And one of those ways is owning assets jointly, naming beneficiaries, giving things away, or creating a living trust. But before we get to joint tenancy, we're going to talk a little bit about something called step up in basis. Step up in basis is where we revalue certain assets at the time of your death so they can step up in value the date of death value. So that applies to real estate or investments like stocks, bonds, mutual funds. So if you've purchased a home, let's say for $250,000, and at your passing it's worth $500,000, whoever inherits the real estate in terms of determining sale or loss on the property will start at $500,000 versus what it's sold for. So it's always better to inherit real estate and investments than to receive it as a gift. Because if I had given that same $250,000 property to my son during my life, and he turns around and sells it years later for $500,000, well, his starting point is what I paid for it, $250,000. So now he's going to have $250,000 of gain to report and pay taxes on that in the form of capital gains taxes. So for him, it would have been better if I had left it to him at my death and given it to him during my life.
Probate is usually cheaper than the capital gains taxes.
Absolutely. But that's only for stocks and bonds, mutual funds, and real estate. It does not apply to cash accounts or IRAs or stuff like that, annuities. Those are all subject to ordinary income tax. Now we're going to talk about joint tenancy. Well, joint tenancy between spouses, Mary and I really like this, especially in the situation where you and your spouse have all the same children. Because regardless of who passes away last, it's still going to your children. However, that's not what we often see. We have a lot of blended families here in the villages, and so who have children from previous marriages. And so what could happen is a lottery situation where one spouse passes away and the surviving spouse says, okay, everything to my children. And we can't really control that unless they've agreed to otherwise maybe in a trust. But again, there's still some risk at changes being made in the future. With blended families, there's no time for planning if it's a joint accident. As I mentioned, children from a previous marriage may inherit, eliminating the other children. And it makes no provision for estate tax planning as well. And we're not going to go deep diving into estate tax, but just be aware, if you're married, your estate has to exceed $26 million before we're concerned about estate taxes. Okay.
One of the things that I see are people that do lottery wills, and those are dangerous, or don't do any estate planning. And they have a blended family and use joint tenancy. The problem is that if one dies and another one dies a few days later, a few years later, everything goes to their children, and the first spouse's children get nothing at all. I often see wills where the husband leaves everything to the wife leaves everything to the husband. But if their spouse is not alive, it only goes to their children, which doesn't seem very fair because now those children inherit everything. Mm-hmm. So we can easily remedy that by just making the wills the same, leaving part to the wife's family, part to the husband's family. So it doesn't matter who dies first. Of course, as Ed has mentioned, the will could be changed, but most people are honest and they won't change it. Mm-hmm.
So that was joint tenancy with spouses. Joint tenancies with children is a little bit different. We're not as big of a fan of this unless it's in certain situations. The risk is that if you own an asset jointly with a child, you as the owner could lose control of that asset. It could be subject to the debts of your child. It could create liability issues if your child is involved in a lawsuit. Now there's an asset they own. And it potentially could lose tax exclusions on the sale of a personal residence and other tax benefits, including your property tax exemption if your child's on your homestead property. If it's not titled properly, you may not get the full benefit of the property tax exemption. So it's important to make sure that if you're going to own something with your child, that's appropriate in certain situations.
I had a very interesting case. It was one of my neighbors, and she was a fun neighbor. She was in her mid-80s. She had red hair that went to the ceiling. I don't think she ever wore heels that were less than 4 inches, usually 6, I think. But she was very, very fun, a bit eccentric. But she'd always been that way. She'd been my neighbor for years, and she hadn't changed. She just was eccentric. So she had a fight with her daughter-in-law. And the daughter-in-law informed her that they were going to put her in a home because she was a crazy old lady. She wasn't. So she comes to my home in tears, just in tears. And I said, no, just calm down. Do you, by any chance, are your bank accounts joint with your son? And she goes, yes. And I go, we need to undo that. So I had to go to the bank. And she wasn't able to close the accounts because her son's signature was needed because he was on the bank account. But she could take all the money out and open up new accounts in her name alone. And then we did a living trust and put all of her bank accounts, all of her investments, and her home in the living trust. and made her brother the trustee. So what happened was the son and daughter-in-law went to the banks to get the money so they could put her in a home. The money wasn't there. So they immediately ran to an attorney to do a guardianship proceeding. They were going to get control of her assets that way. And the guardianship attorney called me and said, well, she needs to be in a home. We're going to do a guardianship proceeding on her. I go, well, that's fine. You can do that. But if you have her declared incompetent, what will happen is her brother will be in control of all of her assets and not her son. Never heard from the attorney again. And she remained my neighbor until the day she died. So a living trust with a power of attorney is probably the best protection against a guardianship proceeding. Now, some of you probably like scary things, Stephen King novels, Freddy Krueger movies. If you do, Google the following: guardianship abuse in Florida. In my opinion, it is better that you pick the person who is going to handle your financial affairs if you become incompetent, rather than having a court do it. And you can pick a family member, you can pick a professional, such as a bank or a financial institution, but you should be the one who chooses so that something doesn't happen to your assets, because there has been a lot of abuse in guardianship proceedings.
So what is another way we can avoid probate in our planning? Well, you can always name beneficiaries on your accounts. However, you want to make sure that those beneficiaries are current. We've seen too often in the past, and it's never a good day for us when we have a surviving spouse, in particular a wife, who finds out that their late husband from years ago had a life insurance policy that he forgot about, but left it to an ex-girlfriend.
They don't like that.
That's not a good day. So you want to make sure that all your beneficiaries are current on your insurance policies and pension plans. Make sure that your beneficiary is alive. We've seen that happen too, that someone's named in it that they were not alive anymore, and sometimes we're lucky to capture it, other times not so much. Make sure all payable on death and transfer on death designations are in place. Over years, many smaller banks are acquired by larger banks, and maybe the paperwork doesn't transfer appropriately. And you want to make sure that your payable on death beneficiary is able to go down to the financial institution at the right time to obtain those assets. We had a woman a few years ago come in. She was the named beneficiary on all of her aunt's bank accounts. And she went down to one of the financial institutions, presented her ID, her aunt's death certificate, and asked to close out the account. And they told her, no, you're not the beneficiary on this account. You're going to have to do a probate. Well, we knew she was the beneficiary because we had seen the statements over the years. In fact, the paperwork. So she called us all upset from the bank saying they're making me do a probate. So I got on the phone with the bank representative and asked him, who do I speak with about the bank paying for the probate? And they're like, what do you mean us paying for the probate? Well, you're telling her she needs one, and we're saying she doesn't. So I believe the bank should pay the probate. So they said, give us 15 minutes. We'll get back to you. Sure enough, 15 minutes goes by. They call us and say, we're releasing the funds to your client, because they just didn't look deep enough in the records, because they in fact had the paperwork showing her as a named beneficiary. So if you have a situation where your bank has been acquired by a larger bank, you just want to make sure your beneficiary designations on those accounts are up to date and current, because you don't want to go through that exercise. Because many banks, I don't know how often they've had someone go to a probate and not knowing any better.
So if your bank is bought by another bank or merges with another bank, double check your beneficiary designations to make sure that they have transferred over.
Yeah, I don't like fighting banks. They have more money than me. So now you can always gift things away. That's a form of avoiding probate, but with gifting, there's some issues. It's difficult to time the gift. It may be subject to gift taxes above a certain amount. Right now, we're free to give $17,000 each year to as many people as we want, free of any gift tax consequence. But if it's above that amount, then you may have a gift tax filing requirement. However, just in one hand is the government is saying you can give things away. They also say, on the other hand, that if you do it in a certain amount of time, if you need Medicaid, then we're going to punish you for that, because we presume you made that gift for the purpose of getting on Medicaid. So you just have to be mindful of the situation when you're making gifts. I'm not saying not to make them, but be mindful of it. If you're above 13 million as an individual, or as 26 million in assets as a married couple, then make the gifts, because we want you to get under that threshold for avoiding federal estate taxes.
Florida does not have an estate tax.
We do not.
Living trust. Many people think that living trust is just, well, they're just for avoiding probate. They do so much more if they are properly written. Now, I have seen living trusts that all they do is avoid probate, but they can also avoid a guardianship proceeding. So what is a living trust?
Well, it's a document that you've created with an attorney that is your plan for taking care of your assets and your spouse if you're married during your lifetime and in case of incapacity. So as Mary mentioned, if you are declared incapacitated, you've named someone in your documents like a trust to take care of the assets and your power of attorney to have someone in place to avoid a guardianship proceeding. So it designates who you want to be making decisions for you in the event of an incapacity. It establishes your plan for distribution at your death so that you said, this is what I want to see happen, distribute it to these individuals accordingly, and avoid the court system. And it creates an entity for holding ownership of your assets. So what you do here in terms of creating this trust, you are funding your trust with your assets. Now that's kind of scary. I know Mary has experienced that fear when she first learned about them, that, who owns your assets now? You've put them into a trust.
Yeah, it scared me in law school. It's like, why would anyone want to get rid of their assets?
Exactly. But in law school, Mary learned, a trust is more like a toy box. I learned it more like a picnic basket, but the toy box is more appropriate because it does have a key that you can lock and unlock as you need to access things, where a picnic basket is more readily accessible by just flipping a lid. But in any event, the idea of funding your trust is actually changing ownership of your assets, whether it's real estate, financial accounts, so that you have now this box to access as you please, to do whatever you want, no different than before. But now you have this box that says, at my passing, or if I become incapacitated, this is who's in charge to manage things and distribute accordingly. So it's very important. It's the most important thing you can do when creating a trust, is to follow your trust to make sure you have your assets in the trust. As we've talked before, anything outside of the trust or doesn't have a beneficiary on it will be subject to a probate proceeding at your passing. What are the advantages of a living trust? Well, it avoids probate. That's always what we're looking to do. And it avoids multiple probate. So if you happen to own real estate in Michigan and in Florida and maybe even Hawaii, we are going to have a probate in 3 different states. So in that situation, a living trust is appropriate, so we can have the title to each piece of real estate in each of those states put into the trust. And then if something happens, it's just a trustee dealing with the real estate and the sale of it and distributing accordingly. As Mary mentioned, it helps avoid a guardianship proceeding. It prevents court control of your assets at incapacity. So just like her neighbor, Mary went about and created a trust and named her brother. And of course, if she was declared incapacitated, her brother was going to be managing those things, and there would not be a guardianship of the assets.
So what are some of the advantages of a living trust? Well, it's private. People cannot find out what your assets are. The trustee has immediate power at death or disability. Often when I have a couple where one of the spouses has been diagnosed with beginning dementia, beginning Alzheimer's, they're still not incompetent. What we will do is a living trust, so that as the person progresses in the disease, the spouse that is not affected can take more and more control, because you have joint trustees, but only one has to act, which means that as the person becomes more incapacitated, or let's say it's a physical incapacity, they don't have to push them into the bank in a wheelchair. They can actually just go in and do it by themselves. So it makes things much easier if one spouse is disabled. Also, when it comes to the point where the incapacitated spouse is no longer able to function, they can either resign, or with 2 doctor statements, we can remove them as a trustee. And now the other spouse has complete control, thus avoiding a guardianship proceeding or having to rely on powers of attorney. Sometimes we do have difficulty getting powers of attorney accepted, and we'll go over that a little bit later. But it is very important to have a Florida power of attorney done after 2011, when the Florida power of attorney law changed. A living trust also greatly minimizes the possibility of a will contest. It is much more difficult to contest a trust than it is a will. and it allows for very quick distribution of assets to beneficiaries. This has become more and more important over the years because it's very difficult now to get insurance on a house that is empty. We have actually had to go to Lloyd's of London. We've had to pay ridiculous prices in order to insure a home during the probate process. With a living trust, they have immediate ability to sell that home so it doesn't have to sit empty for a long time. And there's a lot of problems in the villages with homes remaining empty for a very long time. And also we have to maintain those homes, keep the lawn mowed, especially when you're in any kind of a community with a homeowners association. Mm-hmm. So it allows for very quick distribution. And also the quicker you distribute assets, the less the possibility is of someone getting upset and causing trouble because they have what they should have.
That never
quickly.
Happens. Someone getting upset because it takes too long.
People get upset the longer they have to wait. So this minimizes family friction.
It does. Yeah. In fact, I have a probate going on right now, 15 beneficiaries, and it's one person who's holding up everything, and we're ready to close it out. And so that's why a trust will make life easier for parties involved.
A trust doesn't die when you die. So therefore, it remains in place after you pass away. Now, we're going to talk a little bit about testamentary trust. Testamentary trusts are trusts that arise after your death. Now, those can be done in a will or they can be done in a living trust. My favorite case in law school was the little old man and the cigar. There was a little old man and he loved cigars. His wife did not. She made him go outside in the rain and the snow in upstate New York and smoke his cigars, even in January. He died, probably of pneumonia. But before that, while he was out there smoking his cigars, he plotted revenge, and he got it. He left his wife a lot of money in a weekly allowance, and she only had to do one thing before she got her money each week. And that was to smoke a cigar in the lawyer's office. She was not happy. She appealed to every court in the land, but the court ruled against her. She had to smoke the cigars because no one was forcing her to take that money. She wasn't forced to smoke the cigars. She only had to do it if she wanted the money. So therefore, she had to smoke those cigars. Now, the court's ruling was when you leave money to another person, you can put any string or condition on it that you want to put because the person doesn't have to do it unless that string violates public policy. You can't force someone to change their religion or to get divorced. Interestingly enough, today she would have won her case because smoking is against public policy. But smoking was okay back then. So what are some strings and conditions that we can put on it? Well, we can do trusts where we actually put strings and conditions on the money, such as underage.
Yes. So, if, you can set the ages of 18, which I don't think anyone today would want to leave thousands of dollars to an 18-year-old. So you may be looking at older ages, 21, 25, 30. We've even seen some older.
65.
65. And it all depends on the situation. That you as an individual are going to know your children, your grandchildren best in terms of their ability to manage finances. You can even structure in a way to say you get it installments, not necessarily at a certain age, but 5 years after I've passed away, then 10 years after that, and so forth. So it allows you the flexibility to provide those conditions and terms in which that beneficiary will get those funds. And again, they're not required to do anything. No one's forcing them to do it. It's only if they want the money, then they should do it.
You can also provide for a loved one with special needs without disturbing government benefits. Many people don't want to leave any money to someone with special needs because it will knock them off of Medicaid or other public benefits. If it's in a special needs trust, then we can put the string on it that it cannot be used for anything the government provides. And now we can safely leave money to someone on Medicaid or who needs other government benefits and not disturb those government benefits. I have clients that are taking $350,000 a year medications. Leaving $1 million to that person is not really going to help them. One very sad case, a man did no estate planning whatsoever, and his son with Down syndrome inherited $10,000, which was going to knock him out of the group home that it had taken him a year and a half to get into. So I had to go to court and beg the court not to let him have that $10,000. But it was very complicated where we were able to get rid of the $10,000 to keep him in his group home. We don't want to have to do that. It's very easy. And we, in all of our trusts and all of our wills, do a standby special needs so that if anyone becomes disabled after you do your will, it's taken care of and can be done and decided at the time of your death.
Now we can also provide in trusts irresponsible beneficiaries. If you have a beneficiary who's not really good with money and is very generous with what they have with others, then you may structure it with periodic payments, whether it's at ages or other intervals. You can set up ascertainable standards for distribution, which could mean they get distributions for just their health, education, maintenance, support needs as determined by the trustee as appropriate. You can also provide incentives. You could say, as a grandchild, if you go to college, I'll pay for it, but you have to maintain a certain grade point average and a minimum credit course level. I'll be glad to pay for your tuition, books, and all of that stuff, room and board. Or we actually had a gentleman who was not too fond of his son's career. It was more liberal from his perspective. And he said, I want my son to be productive in society, so I will be prepared to give him $1 for every dollar of earned income that he actually reports on a filed income tax return. So he's trying to convey to his son that I want you to work if you want any money, because otherwise the son was a little bit more willing to just do more liberal things in life and let things come and go. But it was an opportunity to incentivize to make the son more productive in society.
The other thing I'd like to point out is that we can actually do a special needs trust for a spouse. So if you have a spouse that is on public benefits in a nursing home, you can still leave them money without knocking them out of the home by leaving it in a special needs trust. Now, a special needs trust for a spouse must be done under a will. It has to be testamentary. You cannot do a living trust and leave everything to the spouse in a special needs trust. And we've seen many people knocked off of Medicaid because the estate planning was done incorrectly. Because many attorneys who are not specialists in the area do not understand that a special needs trust for a spouse must be testamentary. So it's not in the Florida statutes, it's federal law. So that's what confuses them. So if you have a special needs trust for a spouse, you need to make sure that it is one that arises after death and it's not done within a living trust. We also can protect beneficiaries with financial or family problems.
The neat thing about trusts is they provide flexibility and control. So as long as it's not against public policy, Mary and I can come up with any idea that provides conditions and terms for who the beneficiaries, how they receive those funds. And it's great. And, you know, if we can think it, it can happen. We can do it.
And we do a lot that just simply offer asset protection. So you may have a child that is in a dangerous profession where they can easily sue, or maybe a child that's in a bad marriage. You can leave them their money where they are in control of it, but no one can take it away from them. So personal injury attorneys are just out of luck, and so is a divorcing spouse.
So similar to what we talked about when reviewing a will that's from out of state, we always want to review your living trust that's from out of state. We want to see who the trustee is. Now, unlike the will, your trustee can be anyone. They don't have to live in Florida. They can be a family member. They could be your friend. They could be your attorney. If it's like a trust company or a financial institution, they do have to have a presence in Florida and have powers available to them in Florida to be trustees. But otherwise, there's not the restrictions that we have with personal representatives under a will. Just like with the will, we look to see if you've provided sufficient assets to your surviving spouse. And so are we dealing with an elective share issue where they may be entitled to 30% of the assets? As with the homestead, again, we look, did you leave it to a family member or to your spouse? And have you directed the sale of the home? Again, if you put that direction in the trust, just like in the will, that will open the door for creditors. And so we want to avoid that.
The other thing that I look at is, have you provided for incapacity in your trust? Many simple trusts don't really say what happens or how you're supposed to be taken care of if you become incapacitated. And as I said before, one of the wonderful things about a trust is that it is for you. It protects you if you become incompetent. In all of our trusts, and most trusts done by very good attorneys, they will say in an entire article how you want to be taken care of if you're incompetent, that you authorize your attorney, excuse me, you authorize your trustee to pay for in-home health care. You want to be in a nicer nursing home, that a trustee cannot be sued by a beneficiary for spending your money on you. Other people want perhaps more conservative. Do put me in a cheaper home. I'm worried about my disabled child. I want to preserve the money for that disabled child. So it depends on the circumstances, but you should really think of how you want to be taken care of, and that should be written in your trust.
And it can go as far as attending to your spiritual needs.
Yes.
As well.
I had one lady who loved birds, and she knew that no matter how incapacitated she was, she would enjoy her bird song. So she directed that if she ever became mentally incapacitated, that she would be rolled into the garden each day for half an hour to listen to birds. And she had enough money that could be done. So we put it in her trust.
So again, it provides a lot of flexibility. And just like with the will, we look to see if you have a no contest clause. Again, we would change that to an expenses of challenge provision so that anybody challenging the trust would be responsible for those legal fees and costs associated with it. So now we're going to talk a little bit about power of attorney. In the state of Florida, we have one type of power of attorney. It's a durable power of attorney. Prior to 2011, we had another type called springing. That's no longer the case. We just have the one type now. And the moment you sign it, whoever you've named as your agent has effective authority immediately to act that day. So the person you've selected, you want to have great faith, trust, and confidence in that they're going to act in your best interest, to act loyally, and to follow through on your overall estate plan. Now, unfortunately in Florida, our power of attorney tends to be a little bit longer and more comprehensive than many other states. Many other states, it's perfectly fine to say all powers. Not in Florida. We have to be very specific. So we have like 20 pages of specific powers that your agent can exercise. But if it's New York,
New York has a beautiful power of attorney. All real estate powers, all banking powers, all financial powers. It's very, very short, very simple, and very powerful. But we do not understand the word all in Florida.
So we have to be very specific and lay out the powers. And part of that, too, is we have provisions in there for long-term care planning. If you did need Medicaid, then we have the ability to take the appropriate steps to get you qualified under those powers. Now, in Florida as well, if your power of attorney happens to be rejected, and it's a Florida power of attorney, and it's rejected by a third party, you may have the right to seek judicial relief and attorney's fees and costs for the improper rejection. If your power of attorney from outside of Florida is not consistent with Florida law, we cannot guarantee you it will be accepted by a third party. So it's always recommended that when you move to Florida, you have your documents reviewed by an attorney and have that power of attorney updated so you are consistent with the current laws of Florida.
And remember, a power of attorney cannot be done when someone is incapacitated. It must be done while they are still mentally competent. And that is very difficult for people. They cannot get a power of attorney done when they need it. It needs to be done before. So the first time, if anyone is even diagnosed with Alzheimer's, dementia, they immediately need to get a good power of attorney while they're still competent.
Absolutely. Yeah, because it's easier to do planning when something's onset than it's years later, and then we're running into going to the court system. And then we're going to talk briefly about living wills. A living will is a document that makes it clear that you have certain wishes regarding end of life, including whether you want nutrition and hydration. Some documents give you the option of saying, I don't want any of it, or I want the option to have it, but that's up to you. But remember, whoever you've selected, you want to make sure they're going to follow through on your wishes from a medical perspective. I've seen it where someone's been named and the person says, well, I don't believe in that and I'm not going to comply with it. And then we have a whole nother issue to go through. So again, with any person you're naming your documents to act for you, whether it's from a financial perspective or even a medical perspective, you're going to have confidence in that they're going to follow through on what your wishes and intents are. So be sure that that's made properly. Now, with your living will and your medical documents, we've seen this in blended families. This one of you will name a child as your primary medical decision maker, not your spouse. Keep in mind that if you need healthcare decisions made for you, including where you reside, that child as a decision maker can move you from your home and move you to where they live. And your spouse has no say or right to change that. So be mindful of that as well. If you want your spouse in place, then great, put your spouse in place. But if it's a child, just be aware that the spouse who's left behind is going to be very upset.
Now, the healthcare surrogate, you really need to make sure that that person thinks the way that you do, because they are going to make all healthcare decisions for you if you're unable to. A healthcare surrogate is also the one that is in charge of enforcing your living will. Pick someone that's strong. The hardest thing for a child to do is to enforce a living will. So you need to make sure that the child you have picked is able to do it. My mother and I were having tea one day, and she looks at me and she goes, "Mary Frances," mother called me Mary Frances, "if I had any other children, you would not be my healthcare surrogate." And I'm going, "Mom, what have I done?" She goes, No. I trust you with money. I just don't trust you to kill me." Okay, mother did have a good sense of humor. But that is true. It has to be a strong child, and that'll be a very difficult thing for them to do. I usually recommend just having one, because a doctor needs to be able to look to one person and know that that is the person that's able to make the decision. Of course, you want your children to discuss it together, and you can tell them to do so. But it is easier to have just one that's making the final decision. And then, of course, you should have an alternate. And if you have a child you positively don't want making the decisions, you need to have a lot of alternates so that it doesn't get to that child.
Yeah, and with the healthcare documents too, a lot of people go, I want someone just from a logistical standpoint. They're closer in time, and doesn't mean they're the best one. Just because they're closer and live near you doesn't mean they're the best one. Again, you want someone that you're going to have confidence in, that they match your wishes and will follow through on them.
Thank you.
So I think that's it. Yeah, we appreciate your time, and Lisa, we thank you for inviting us to present to the group.
We have lost you, Lisa.
Oh, she's muted.
I'm getting unmuting. Yep, thank you. Wow, I learned an awful lot. Thank you. Thank you so much for joining us.
You're very welcome.
I know that you want to have some questions directed towards you at the office. So I think that we have your information, and I did post it on the side of the screen here. So if families would like to get in touch with you, I know that you are in the Lang Eye building, and they can make an appointment to see you. You're booking about a month out at this point. Is that about right?
Usually 3 to 4 weeks.
Yeah, about that time frame. So
Okay.
Yeah. We do offer free consultations for estate planning. So if anyone is interested in a will or a trust, we also will review them from out of state, because out of state wills and trusts do need to be reviewed, as do out of state powers of attorney.
Yes.
But if you've done your planning yourself, like a form from online, we cannot review that for liability, malpractice issues. So it's only got to be a document prepared by other attorneys.
That's good to know. I do have some families that think that that's enough, or the VA form that they got handed at the VSO office. That is not, that's something that you need to look at, and perhaps you would like to work on the legal papers if that's what they have. Is that correct? Is that not typically usable?
We can't look at anything that they drafted themselves and guarantee that it's correct because of malpractice issues. We have malpractice insurance and want to keep it. But sometimes a financial institution will have a power of attorney just for that purpose, or the VA has their own health care. And that's fine for the VA or that one financial institution.
Okay. All right. So I think the best thing for everybody to do is to make an appointment, right? Because again, this is a really important part of our lives, right? Pre-planning, making sure that we're safe, making sure that we've got those papers done, especially for those families that I work with that have no spouse, right? They had a spouse and their spouse has passed. Life has changed, and maybe again, the family situation has perhaps changed. Or if the families I work with, one has been diagnosed with something, it's now time to come in and really look forward, thinking about how are we going to mitigate costs, manage finances, look at the legal papers, figure out who's going to speak for whom, especially in those blended families. So yeah,
Mhm.
it's important for everybody to, again, have those reviewed and know where they are and make sure that the families know where the legal papers are in an emergency. Is there anything else that we should add? Is there anything else you can think of? This was very comprehensive and I really appreciate your time.
No, I think that's it. I think
Thank
everything's
you
in
for
good order.
having
Thank
us.
you for having us. We appreciate it.
Okay. All right. I think Maureen, you have another slide we're going to add up here real quick. So again, my name is Lisa Honka and I have a company called Your Key to Senior Living Options. We do offer a caregiver support group. So I'm just putting that information up on the screen for those people who are caregivers now. It is actually done by Josephine, who works for me at the Wildwood Community Center. And then I think we have some other upcoming events. Tomorrow, I'm actually organizing a Living Well Expo for those people who are in the midst of managing Parkinson's, and that's going to be at Inspiritus of Wildwood. And then also we're going to be doing How to Pay for Senior Living at Rock of Ages Lutheran Church. And we're going to be working with the Sheriff's Department on elder abuse and neglect. So we have that coming up in November. So again, I want to thank you all for joining us. And hopefully you've learned a lot. I appreciate your time. I know you're very busy and I've learned a great deal. So thank you. I hope you have a great day and thanks for joining us.